Well, thank you everyone for coming to this Center for Business Law talk featuring one of our own, Adam Hofri-Winogradow. Is that how you pronounce it?
Yeah.
Okay.
A little more American. Say Winogradow.
Okay. Is Winogradow, is that okay? Or?
Absolutely.
Okay. Well, anyways, that's not the subject of our talk. Adam will be presenting his paper, Equity Has No Place Here. So let me introduce Adam very briefly. So Adam's research and teaching focus on trusts, including comparative doctrinal treatments of trust law topics, empirical studies of the way trusts are used in practice by different sorts of clients, studies of many jurisdictions' recent dramatic reforms to their law of trusts, looking to make that law alternatively client and practitioner friendly, historical and socio-legal accounts of the development of trust law in practice in England and Palestine, Israel, and theoretical accounts of the social and economic functions trusts fulfill, including as a tool for subverting other parts of the law. So Adam is an expert on trust law, although in today's paper he's not going to be talking about trust law per se. He's actually going to be talking about equitable doctrines in the area of tax law. So his paper, Equity Has No Place Here, is on the subject of rescission in tax jurisprudence. It's a very interesting paper. I've read it. I provided some feedback, and I'm looking forward to hearing Adam discuss it. So without further ado, why don't we just go ahead and get started?
So thank you so much, Camden, for the invitation to speak as part of the Center for Business Law series, and of course for this kind introduction. So let's just jump right in. So equity is a part of the common law that's often associated with doing justice between parties. And Irit Summit, who was a visitor here last week or the week before, she wrote that the characteristic function of equity is promoting correspondence between legal liability and moral duty. And so it may come as a surprise that equitable remedies are available in circumstances that may have little to do with correcting injustice per se. Both in Canada and in the UK, rescission and rectification in equity have been used to retroactively eliminate the disappointing results of tax planning gone awry, leaving planners and their clients free to try again to minimize their tax burden, or indeed leaving them with improved planning, resulting in less tax being payable. While such use of equity supports the realization of transferors' intention to save tax, it undermines the tax and transfer system and its redistributive goals. So this interesting situation is still the status quo in the UK and has for more than 20 years and until 2022 been the status quo in Canada. Breaking with the status quo, however, the Supreme Court of Canada has in Canada and Collins Family Trust largely eliminated such use of equity in Canada, except for rectification of documentation errors, clerical errors. And so my goal with this paper is to figure out what the law should be regarding the availability of rescission and rectification to retroactively eliminate or amend error-based tax planning that has led to what for the taxpayer are disappointing results. And so the plan for my talk is pretty simple. I will first delineate the recent history of the law on topic, and then I will discuss what the law on topic should be. Right? So easy, a two-part plan. So let me start with a brief history of using equitable remedies to reverse failed tax plans. Both rescission and rectification have been used for this purpose, and I will start with rectification and then move to rescission. So to start with rectification, Canadian courts have between the years 2000 and 2016 made available a strikingly extended version of this remedy, where rectification was sought to revise a transaction having tax results that taxpayers found disappointing. Prior to this extension, rectification could, under Ontario and Bramco holding, rectification could be available to fix the disappointing results of a tax mistake where a taxpayer had a common and continuing intention to achieve or avoid a specific fiscal result which was not properly expressed in the documents executed. In other words, back then, before the year 2000, rectification in the tax planning context operated like it operates in other contexts. It operated to conform documents to parties' intentions, while the documents did not express these intentions correctly. That's normal rectification. Then, between the years 2000 and 2016, many Canadian courts have radicalized rectification's pro-planning bias. Right? Even normal rectification has a pro-planning bias. Then our courts radicalized that bias in the tweak they made to rectification doctrine starting in the year 2000. Starting in this case, Attorney General of Canada and Juilliard, our courts made rectification available even where a tax plan was in fact executed correctly and was perfectly reflected in documents executed. However, as a result of a planning mistake, the plan had tax results that disappointed taxpayers. And so Juilliard and the later cases applying it made rectification in the tax planning context more generous than rectification is in other contexts. Non-tax rectification, rectification outside the tax context, adjust documents to reflect the parties' agreement, while in this tax planning context, rectification came in the Juilliard line of cases to redo transactions, to conform to parties' tax-efficient intentions or expectations, even while the documents as originally executed reflected taxpayers' agreement or tax minimization plan quite correctly. And so this Juilliard line of cases was brought to an end by one person, Justice Russell Brown. And I invited Russell to this talk. He unfortunately was, as you know, he is now working in Vancouver. Unfortunately, he was on a plane to Toronto this morning, and so he couldn't be with us, but he's very much a major figure of this particular paper. And so Justice Brown first pointed out how unorthodox the Juilliard line of cases was as a judge of the Alberta Court of Queen's Bench. And once elevated to the Supreme Court of Canada, Justice Brown held in Canada in Fairmont Hotels that, quote, where an instrument recording an agreed-upon course of action is sought to be rectified, the party seeking rectification must identify terms which were omitted or recorded incorrectly, and which, correctly recorded, are sufficiently precise to constitute the terms of an enforceable agreement, end quote. And so Fairmont Hotels rejected the special rectification regime Juilliard created for tax mistake cases and conformed Canadian law governing rectification of tax mistakes to Canadian law governing rectification in other contexts. Fairmont requires identifying specific terms which were agreed, but omitted or recorded incorrectly for rectification to be available. Moving on to the rescission side of the story. And so rescission in equity, right? Rescission also exists outside equity. We're here discussing rescission in equity. Rescission in equity was between the years 2015 and 2022 available in Canada as an alternative remedial route for eliminating the regretted results of tax mistakes. Rescission became available in Canada in this context by way of the UK Supreme Court decision in Pitt and Holt being applied by some Canadian courts. And so Pitt and Holt provided in UK law that dispositions can be set aside in equity where there was a causative mistake basic to the transaction of sufficient gravity to make it unconscionable on the part of the recipient to retain the property transferred. The gravity with which Pitt was concerned is of the injustice created by the disposition. And UK courts have, in fact, found many tax mistakes to be of sufficient gravity to justify rescission, since Pitt was handed down in 2013, and this is still the state of UK law as we speak. And I can give you a long list of references where Pitt was applied to reverse tax plans that had unfortunate effects for taxpayers. And so Pitt itself was a sympathetic case. I mean, the facts are well known among the people who deal with this type of law. Mr. Pitt received compensation for injuries he sustained in a traffic accident. And so he became disabled. Mrs. Pitt received advice, and then, according to this advice, settled the sum received on a discretionary trust. Unfortunately, her advisors made a basic mistake. Neither she nor her advisors realized that this structuring choice would produce an inheritance tax liability under UK tax law. That liability could have been very easily avoided had the trust been structured as a disabled person's trust, an alternative trust form expressly provided for by UK statute. It was there in the statutory text, yet these expensive advisors didn't use it. So one can see why the UK Supreme Court was moved to grant rescission in equity, making that remedy more broadly available under UK law than it was until this UK Supreme Court decision in Pitt and Holt. And so that's a UK story. This rule, the rule in Pitt, was first applied in Canada in the case of Re Palin Trust. Re Palin was a very different case to Pitt. Palin involved a complex series of contrived transactions intended to avoid tax payable on a corporate dividend. So, it's always a question whether one should try and actually describe tax plans in public talks. I will provide a very abbreviated, simplified description of the plan in Re Palin, omitting many of the various steps involved. And so the sort of simplified version is the following. A holding company holding shares in an operating company. This holding company settled a trust, then sold shares of the operating company to the trustee of that trust. Now, the trust, as settled, was settlor interested. What does this mean? It meant that this holding company that settled the trust reserved a right to call for the shares to be returned to it. This makes the trust settlor interested. Normal trusts are not like this. And so this operating company then distributed dividends to the trustee. So because the trust was settlor interested, the dividends were attributed to the holding company for income tax purposes under the attribution rules in subsection 75 sub 2 of the Income Tax Act. These attribution rules require the attribution of income accrued in settlor interested trusts to their settlors. Now, this attribution, of course, originally enacted as an anti-avoidance rule, was successfully used as a tax minimization tool in this plan. The attribution made the dividends intercorporate dividends paid by one corporation to another. And intercorporate dividends are effectively tax-free, as corporations may claim a deduction for dividends received under ITA subsection 112 sub 1. So this series of transactions in Re Palin was not a mistake. Remember, we're talking about tax mistakes. This was not a mistake in 2008 when the plan was created. This was a highly artificial tax minimization plan that has long been a common practice, a matter of common practice among Canadian tax planning experts. The plan was artificial, sure, but it reflected a widely accepted understanding of the law. So as noted above, one element of the plan was attribution of trust income to the trust settlor under the anti-avoidance rule in section 75 sub 2 of the Income Tax Act. Like some other anti-avoidance rule, rules, this rule has long been exploited as an instrument of tax minimization. And so in 2011, the tax court decided in an unrelated case, in the case of Sommerer and Canada, that attribution under section 75 sub 2 does not occur while the property gains on which were sought to be attributed when this property was sold rather than gifted to the trust. Right? This was a change in the law. And this view was later upheld by the Federal Court of Appeal in 2012. And so in 2014, the CRA reassessed Palin's trust for the year 2008, noting that shares of Palin's operating company were sold, not gifted, to the trust. And given the decision in Sommerer, the CRA then determined this commonplace tax plan Palin used to produce a large and hitherto unsuspected tax liability, right? Section 75 sub 2 no longer applied. And so the dividends the operating company paid to the trustee were no longer attributed to the holding company that settled the trust. They were therefore not eligible for the intercorporate dividend deduction in subsection 112 sub 1. These dividends were instead taxed in the hands of the trust, which as an inter vivos trust was subjected to the top marginal tax rate under subsection 122 sub 1. Right. And so the BC courts granted rescission of the tax plan because not only was Palin's plan not considered aggressive, or so the BC Court of Appeal held, it did, David, the plan also relied on the CRA's own long-standing understanding of the law. Okay, so the BC courts, both Supreme Court and Court of Appeal, granted rescission of this tax plan. So Palin's case never got to the Supreme Court of Canada, but a few years later, two tax plans, nearly identical to each other and to Palin's plan, came before the Supreme Court of Canada in the case of Canada and Collins Family Trust. And once again, it was up to Justice Russell Brown to narrow the ambit of equity in Canadian law. Justice Brown extended the restrictive approach he laid down in Fairmont. He extended it to rescission, noting that the UK case of Pitt contradicts Canadian law in holding that equity can relieve against a tax mistake. And then Justice Brown said the following: equity has no place here. There being nothing unconscionable or otherwise unfair about the operation of a tax statute on transactions freely undertaken, it follows that the prohibition against retroactive tax planning, as stated in Fairmont Hotels, should be understood broadly, precluding any equitable remedy by which it might be achieved, including rescission. Right. So this gives me this zinger I've used for the title of the paper, right? Equity has no place here. Okay. So Justice Brown's position in Collins has the merit of clarity. While tax planning for tax minimization purposes is allowed in Canadian law, subject to the general anti-avoidance rule, specific anti-avoidance rules, and judicial anti-avoidance doctrines, such as the sham doctrine, the courts will not extract taxpayers whose plans have led to disappointing tax results from their predicament by way of equitable remedies. Justice Brown's decisions in Fairmont and Collins stand out for their decisive, cut-and-dried character. They have made Canadian law governing the availability of equitable remedies to retroactively erase mistake-based tax planning far more restrictive than either English or US law on topic. Okay, so that's the history. But is Justice Brown's position, which is now Canadian law, is it right? What should the law say regarding the availability of equitable remedies to erase or modify error-ridden tax planning that has had disappointing results for the taxpayer? This question will be the focus of the rest of this talk. And so I see two fundamental reasons for allowing equitable remedies to reverse failed tax planning. I will first discuss arguments for allowing this and then discuss some arguments against allowing this. And finally, we'll let you know what my view is. And so the arguments for allowing equitable remedies to reverse failed tax planning are the following. First, our law sees tax planning as legitimate. This is obvious in our case law, which continues to celebrate the so-called Duke of Westminster principle, quote, that taxpayers have the right to order their affairs to minimize tax payable. And the majority of the Supreme Court stated fairly recently in the case of Canada and Alta Energy that, quote, taxpayers are allowed to minimize their tax liability to the full extent of the law and to engage in creative tax avoidance planning insofar as it is not abusive within the meaning of the general anti-avoidance rule, end quote. Legislation actually sets out acceptable tax minimization plans for taxpayers to follow. So, since much tax planning is seen as legal and legitimate, neither illegality nor public policy apparently prevent private law doctrines enabling reversal of mistake-based contracts and dispositions from being applied to contracts and dispositions undertaken in a tax planning context. So that's one reason to allow the application of these doctrines to error-ridden tax plans. Another reason to allow this is that given the extreme complexity of tax legislation, the risk of such mistakes is significant. Most cases where taxpayers applied to have their tax planning rescinded or rectified originated in planning mistakes made by well-known, well-compensated tax advice professionals who ignored the impact of well-known tax rules on the planning they sold. And so the risk of tax mistakes is quite high. And it is further aggravated by the Canadian rule that changes to tax law may operate retroactively. And further, the results of tax mistakes can be truly devastating for the individuals involved. There are also, however, some reasons, mostly of distributive justice, against granting equitable remedies to reverse failed tax planning. As Rory Gillis noted, quote, tax avoidance has at least two distributive effects. First, it reduces government revenues, which are often used for redistributive expenditures. And second, it disproportionately reduces the tax liability of high-income individuals, end quote. And so, in other words, tax planning creates inequality in disrupting the operation of the tax and transfer system, society's chief instrument of redistribution. The granting of judicial assistance to tax planning clients faced with disappointing results aggravates this inequality. Given the cost of litigating all the way to rescission or rectification, access to such judicial assistance may itself be unequally distributed. One is also minded to ask whether the judicial system, funded with taxpayer money, should spend that money on helping the better off reduce the tax yield. Further, the availability of equitable remedies in cases of failed planning makes planning less risky and so incentivizes taxpayers to plan, increasing the amount of planning and probably decreasing the tax yield. And so a different type of argument against granting equitable remedies to reverse failed tax planning focuses on those remedies being equitable. Equity has traditionally focused on correcting injustices in private law relationship, while tax is a public law matter. It is therefore doubtful whether equity should involve itself in taxpayers' relationship with the state. So this argument is available in the literature. I'm afraid it appears less convincing to me. Right? As Aruna Nair and Irit Summit have made clear, equity has long taken societal welfare and distributive justice into account. as in protecting bona fide purchasers of property despite the harm thereby done to assets' erstwhile owners in order to bolster commercial certainty. Another interesting example of equity giving weight to issues rather than the relative merits of private parties before the court dates from the 18th century, when English chancellors used to relieve against contracts entered into by expectant heirs, right? The heirs of fortunes, of propertied families. Chancery, the English Chancery, used to assist these heirs by relieving against contracts they have entered into, in alienating or charging their rights to the family fortune. So equity relieved such debtors, not because of their convincing private law cases, but because, to quote Lord Hardwicke, the English Chancellor in the first half of the 18th century, equity relieved them to, quote, prevent the ruin of families, end quote. So as Catherine Macmillan noted, equity sought to set aside the bargain with the heir in order to implement an underlying principle of public policy, namely the prevention of damage to the heir's family, and indeed to great families, meaning propertied families generally, end quote. So in other words, 18th century equity acted to maintain the concentration of wealth in the then ruling class. Preserving this concentration was then a matter of public policy. So we see equity has long had no problem being alive to public policy considerations in deciding private law cases. Current public policy prefers the disaggregation of wealth. One could hardly claim that taking this public policy into account is somehow foreign to equity. Okay, and so finally to my own view of this topic. So what makes identifying the right answer to whether equity should provide remedies to avoid or amend tax planning gone wrong? What makes this so difficult is that Canadian law actually accepts both redistribution by way of government tax and transfer and tax avoidance planning. So Canadian law accepts both, which is what makes balancing them and coming up with a proper solution quite difficult. And so, given that allowing equitable erasure of mistaken tax planning is likely to increase the amount of planning and reduce taxes payable, my view is pretty restrictive. I believe that rescission and rectification should be available in this context only when an individual taxpayer would face destitution should they not be granted. Tax shouldn't beggar anybody. It is a mechanism of social equalization and improvement. It's not a trap. And so while cases where taxpayer beggaring tax burdens resulted from taxpayers' ignorance seem more deserving of judicial assistance than cases where similarly crushing burdens result from tax avoidance planning gone wrong, even the latter type of case should be afforded assistance where the burden is truly crushing, given, again, our law's fundamental acceptance of tax planning. And so my proposal is more generous on rescission than current law, which makes rescission unavailable in tax mistake cases, period. On rectification, my proposal is less generous than current law, which does grant rectification where a specific tax minimization plan is inaccurately recorded. So if you think about it, our current law on rectification incentivizes taxpayers to construct very detailed, specific tax minimization plans, which is surely an inappropriate incentive. You know, if current law imposes too much tax, this burden needs to be lessened, either by cutting rates or by reforming tax bracket schedules so that higher rates only apply to higher incomes than at present. I invite you all to compare our own tax rate bracket schedule to that in California. You will be amazed, right, by the comparison. So current tax burdens may be too high, even if So they should not be indirectly cut by providing judicial assistance to taxpayers whose tax minimization plans have gone wrong due to mistake, as the UK Supreme Court said in Pitt. Artificial tax avoidance is a social evil which puts an unfair burden on the shoulders of those who do not adopt such measures, end quote. Which is to say, it has regressive distributive effects consonant with the public policy of 18th century England, sure, but not with that of the present. So while our law accepts such avoidance, it should not provide judicial assistance at taxpayer expense to disappointed planners, except in cases where planning gone wrong will render taxpayers destitute, truly destitute, if not erased by the court using some equitable doctrine. Okay, so as the revenue has repeatedly pointed out in litigating rescission and rectification cases in the tax context, taxpayers faced with a ruinous tax burden have remedies at their disposal other than equitable remedies. Taxpayers can appeal their tax assessment to the tax court. They can sue their professional advisors for negligence. And they can also apply to the Minister of Finance for an order in council for remission of tax where its collection is unreasonable or unjust, or where it is otherwise in the public interest to remit the tax. Each of these alternatives differs from equitable remedies granted in provincial court. The tax court has no power to award rectification or set aside transactions as between the parties. It may, however, and it has recognized that a transaction is ineffective under provincial law and treat it as having been set aside. A negligence suit against professional advisors responsible for a tax mistake is only possible where the advisor's liability for negligence has not been ousted in some applicable document. A negligence suit is also an expensive, slow, and uncertain process. Applications to the Minister of Finance to remit tax, finally, are uncertain, complex, and slow, with the minister very likely to guide him or herself by the CRA's view of the situation. And so Joel Nicketman, who was counsel for the taxpayer in both Palin and Collins, and so not exactly a disinterested person here, he wrote that, quote, "The test is not whether there exists a possible alternative remedy, but whether that remedy is a practical, realistic remedy. Only in a rare case would suing one's advisors or seeking remission meet that test." And so my view on this alternative remedies issue is that given the cost of judicial proceedings, taxpayer beggaring tax burdens produced by planning mistakes are better removed by way of administrative recourse than by way of judicial recourse. Where administrative recourse is not realistically available or is not cheaper to provide than a judicial proceeding, then equitable remedies should be available to reverse taxpayer beggaring tax mistake-based planning. And so when is recourse realistically available? It is realistically available where the taxpayer has a means, other than applying for equitable remedies, of having the devastating results of their error-ridden tax planning eliminated. Such elimination could take place other than by eliminating the tax assessment, as by the taxpayer's advisors compensating the taxpayer for the results of their negligence. A putative recourse that is not practically available, however, as well, negligent advisors are protected by a liability exemption clause, or where tax remission is never or very rarely in practice granted, such recourse would not suffice or should not suffice to exclude equitable remedies in the devastating cases where I suggest they be made available. And now, finally, focusing on the front row, before I conclude, I should mention two alternative views on the topic that have been suggested to me by our colleague David Duff, who is sitting right here and whose views have now become part of the paper and part of the talk as well. And so, David suggests two alternatives to the view I suggested. One alternative David suggests is that rescission or rectification should be allowed depending on the type of mistake involved, where the tax plan in question was such as Canadian law sees as legitimate, and equitable relief should be refused where the tax plan was such as Canadian law sees as abusive. And some may prefer a rule that is focused on the substance of the plan rather than on the results of its failure. It still seems to me, and David may think differently and may perhaps be correct, but I don't think so at present. It still seems to me that the line between legitimate and abusive tax plans is in the eyes of the beholder, rendering this alternative rule highly uncertain. I mean, consider Palin's plan, which I tried to describe earlier. The BC Court of Appeal considered this plan not aggressive. David considers it very aggressive. What does this tell us about the certainty or the determinacy of classifying tax plans into legitimate and abusive? And so, on the other hand, what I suggest is for remedies, for equitable remedies to be available when absent these remedies, the taxpayer would be made destitute by the tax effects of their planning. So destitution is more easily definable than a tax plan being legitimate or abusive. You can define destitution, for example, as the absence of means allowing a person to live above the poverty line. Okay? Or you can adopt any other reasonable definition. You can define the line of destitution, where a tax plan dumping a taxpayer under this line would make them a potential beneficiary of rescission or rectification in this context. And so another alternative rule David mentioned is refusing relief in all cases of tax mistakes, directing disappointed taxpayers to sue their tax advisors that put in place the ill-advised tax plan or supplied the error-ridden document. So as David noted, while the government is better placed to absorb and spread the loss than even the largest corporate tax advisor, advisors are best placed to prevent the loss. This is true. They're the cheapest cost avoiders, to use the language of early law and economics scholarship. Imposing the loss on advisors, however, would require disallowing the duty waivers and liability exemptions advisors use. And should waivers and exemptions be disallowed, tax advice would probably either become more expensive or far less broadly available, or both. And so, given how complicated tax law is, I believe tax advice should stay available and at as affordable a price as possible. And for these reasons, I believe my view to be preferable to both current law and the two alternative solutions. And so, thank you. And I look forward to your critique, comments, questions, penetrating criticisms. Thank you so much.
All right. Thank you so much for a great talk. So we have plenty of time for questions, and I'm going to exercise my prerogative as director of the Center for Business Law to ask the first question. So my question is, it was on the very last point you made about David's suggestion that relief should be, directed against tax advisors. And your counter argument was that this would just create a regime in which tax advisors would customarily demand waiver of their duty of care. Is that right?
No. What I said is that currently many advisors use duty waivers or liability exemptions.
Yeah, so that's my question. Yeah, I'm just to clarify. So under Canadian negligence law, you can just waive your duty of care, because under Canadian corporate law, you can't. So I was just, I'm not an expert on general negligence law.
I am primarily familiar with trust practice. And so in trust practice, using liability exemptions is commonplace.
And
It's commonplace.
it's common, but do they hold up in court? Is that, they hold up in court? That's
Held
that's
up
kinda
in court. Well, there haven't been many Canadian cases on topic, but
Okay.
there have been some, and yeah, those exemptions are currently considered
Okay.
legal.
Interesting.
Yeah.
Okay. Thank you very much. Other questions?
David.
Okay, well, I can't ask questions or comments that you've already addressed, so I do have a comment and a question, though. One comment is, I think you overplay the extent to which Canadian law says all tax planning is legitimate, and you've cited Alta Energy for that. Alta Energy authored, it's a 6-3 decision. The author of it, Cote, who was the one who dissented in the Collins Trust case, right? And also dissented in the subsequent Gar case in Dean's Knight, which is authored by Roe, who dissented in Alta. And so there's been a shifting attitude toward tax avoidance and the application of the Gar. As you said, the courts still refer to the dupe, always subject to the Gar, and that has been a long evolution of sort of shift in the culture of the court that still ongoing, but I think it's in a direction that Dean's Knight is a better reflection of it than you're citing Alta Energy. That's a comment. So sort of playing up that side of it is like, well, that's a very strong norm in Canadian law. I think it's overplayed a little bit in the paper. Likewise, I think associated comment saying that, aggressive stuff is simply in the eye of the beholder. I think there's a rigorous process under the GAR to decide what's abusive and what's not abusive. And although I think the non-expert BC Court of Appeal couldn't draw that distinction in Palin Trust, I think anyone who knows a fair bit about tax knows there's a big distinction between a plan like Palin Trust or Collins Trust, where you basically avoid corporate tax and you pay out dividends tax-free to beneficiaries of a trust, versus the Juilliard, where there's a rollover that's allowed under the Act that's considered completely acceptable to transform your property into corporate ownership, and they kind of messed up on issuing shares, I think, in that case. It wasn't an abusive transaction at all. So that distinction, I think, can be drawn, not always easily, but it's drawn by law. Okay, those are my comments. The question is the following. Because you think the abusive stuff's in the eye of the beholder, but destitution somehow is clear. What do you mean by destitution? And in the Pitt case, where there was going to be a big inheritance tax, is that destitution or not destitution?
Okay, so thank you, David. And I probably should add to the paper, which is kind of short, a discussion of the growth of the definition of what might count as legitimate versus abusive tax planning under Canadian law. So yeah, I will definitely refer to this. Regarding defining destitution, this doesn't strike me as difficult, and I suggested one definition in the talk. The definition I suggested was saying destitution is falling underneath the poverty line. Statistics Canada has a definition of what counts as the poverty line in Canada. And so Statistics Canada can count how many Canadians fall under the poverty line in each time. And so one definition of destitution would be not having the means to rise above the poverty line. That would be one definition. We could suggest others, but the notion of destitution is definable. It can be made very concrete enough for the rule I suggest to be applicable with a reasonable degree of certainty.
So Pitt would qualify then, probably.
Now, Pitt, as you see in the many later English cases applying it, has produced a very uncertain law, which on the one hand is an equitable tradition, and on the other hand is a problem, right? Because Pitt has changed the English law of rescission for mistake quite dramatically. For example, there was an old English rule, not so old, but from the 1990s, saying that rescission in equity would be available. Well, the mistake was as to the effects of the disposition, not as to its consequences. So tax results would count as consequences, not as effects, and so would not justify under the English law before Pitt and Holt rescinding the relevant disposition. This distinction, which was fairly well established in English law before Pittenhold, was swept aside, and the law opened up to a sort of judicial discretion, which is in the equitable tradition, but is wide open and has, in practical terms, meant that the route to having your error-ridden tax plan erased under English law is wide open.
Yeah, I don't want to harp on the destitution point because I don't have any view on it. I don't know if it's a good idea or not. But I'm just wondering, when you talk about like defining destitution, I think that's a good point because isn't the poverty line, isn't that an income measure? Right? Like doesn't Statistics Canada deem people to be impoverished based on their annual income?
I think so. I'm not sure.
So what would you do with a situation where like you have a taxpayer who has like really high human capital and expected future earnings, like a lawyer or a doctor or something, and then they engage in a bad tax plan, which completely wipes out their net worth, right? So they're like starting from zero. Would that person be, but they could potentially be making $100,000 a year. Like, would that person be destitute by your measure?
Great question. In other words, every bright line rule in the law can be gamed. This is true. And this is, of course, one reason why we have equity, right? I mean, judges would surely retain an element of discretion, even if we do find a bright line rule defining destitution necessary for these purposes. Judges or courts will surely retain an element of discretion to try and counter this sort of gaming.
It would still have to be like a rule of thumb, right? Like
it would be.
So equity has a place here.
In my view,
that specific issue.
In my view, it certainly has a fairly limited place here, right? I mean, the fairly dramatic zinger saying equity has no place here is Justice Brown's. It's not mine. In my view, it has a limited place. And what we are now discussing is how that place should be defined and delineated. And I suggested one definition that could be formalized into a bright line rule. And you're saying, quite truthfully, well, people could game that rule. And I'm admitting this.
Well, it's not really gaming it. I'm just describing, like, that's just like a possible, like, fact, that's just like a life situation. Like, I don't think they would be intentionally gaming it. It would just be, I don't think it matters. I mean, like, yeah, you would just, I'm certainly, I think I'm, now that I think about this, I do think it might be a little bit harder to define what destitution is in like a rigorous way than you're suggesting, but I haven't thought about it carefully.
Thank you. Dennis.
Yeah, I kind of find that interesting as well because, and I may be wrong because I know so little about tax law, but say, for example, it's a tax planning scheme that involves 3 or 4 people together. It's unsuccessful. And 2 of them survive quite comfortably because they've got a whole lot of riches stored somewhere else. But one, really took a gamble with this particular thing and he's lost. So he meets your, economic devastation test. But isn't that strange where in the same kind of plan, you've got 2, who are going to have to suffer the loss, but one who's destitute doesn't. And what strikes me about that is that going, to Brown's thing, that this really isn't a matter of conscience. I think you're right. It is still a matter of equity, but it's the old equity before Hardwick, who you mentioned earlier on, Lord Hardwick. And it was really an equity where equity varied according to the length of the Chancellor's foot. The Chancellor just sits there and sort of decides, hey, this is kind of hopeless for this beggar. Oh, well, we'll let him off, and so then you do game it. I think it is a gaming thing.
Well, I mean, Pitt and Holt, the rule governing the availability of rescission to reverse transactions in Pitt and Holt certainly is a Chancellor Foote's like equity. Yeah, so that type of equity is certainly, occasionally at least, alive and well, certainly with English law, whereas our Justice Brown was adamantly opposed to this kind of equity. So to treat the specific fact situation you brought up, right? A situation where a tax plan involves several people, and one is beggared by the failure of the tax plan. The others are better off. Should this count as destitution? So I guess, the practical judicial approach would say that this should depend on the likelihood of these other folks helping this guy. Okay, if they only join together for the planning exercise, then maybe, yeah, because they're not likely to help him. They're likely to be pretty mad. But if they are family, then maybe not. Okay, this will.
Sorry, not to be facetious. If in
Don't
fact
be.
you are destitute,
Hmm.
isn't the whole point of the tax system to kind of help you? So, drawing on taxes that are paid from other people, right? You're part of the redistribution part, so you get back on your feet.
Great point. So I guess that if the state, this bolsters the justification for my suggested rule, because what you're essentially saying is that this person has been, if they have to pay the tax imposed as a result of their failed plan, they will be rendered destitute, which means that they're going to get all kinds of tax credits and supports and whatnot anyway. The state is going to have some expenses to support them as a result of their planning failure. So this being the case, might as well grant them rescission or rectify their plan anyway. That's a nice point.
Excellent. Really.
Thank you, Dennis. Any other questions? David.
Sorry, when I gave you comments on the paper, when I saw what you said, I think the first bullet point wasn't quite what can you go back to that? And I think the second bullet point about risk was something, but I think I may have said in comments that I feel a bit more sympathetic to rescission or rectification, where whatever the plan was is just something that's clearly offered by the Income Tax Act and they screw up. My example was transferring property to a corporation, which can be done on a tax deferred basis, and sometimes the shares aren't issued appropriately, so you don't qualify. But there's nothing about the plan that is abusive and is problematic and so on. More sympathetic, though I'm not sure that means I would say any circumstances, but if it's documented incorrectly, I think that's a legitimate case versus the cases like the Allen Trust, like the Collins, where it's a sophisticated plan where somebody's figured out a way to not pay any tax. And an argument was made it was consistent with the legislation, but even then, I think that's highly questionable. And some of those earlier cases could have been subject to the general anti-avoidance rule. I guess it took a while for the CRA to get around to doing that. And in the meantime, summer happened and reversed those plans anyway. So I think that first bullet point, it's not like a rule I was articulating. I just want to say that if it's some other petition for the paper, you can say David upset this. I'm not sure I said quite that. I just a bit more sympathy to those things. But I think in terms of the old traditional, like you've got the documentation wrong, then this is maybe a factor to consider.
Thank you.
All right.
So.
We have a question in the chat asking, it's a two-parter. So first of all, why are the errors that are at the root of these cases not covered by tax lawyers' professional liability insurance? And then part B is, why is seeking recourse against the lawyer/advisor a less successful path than seeking an equitable remedy?
Okay, so let's take this one by one. The first part was, why were the heirs, and as in a person's heir in an inheritance law sense?
No, why the errors?
Oh, the errors,
of these cases not covered by professional liability insurance?
Yeah. Well, they might well be covered by professional liability insurance if the insurance ceiling has not been reached, but the relevance of insurance would depend on whether there was a duty waiver or a liability exemption clause in place, right? If there was, we would not get to a liability. So if there's no liability, you don't need to sue your insurance. And then the second piece was?
Why seeking recourse against a lawyer or advisor is less accessible than seeking an equitable remedy?
Yeah, so the The reason it might be less accessible is, again, those same duty waivers and exemption clauses. Okay, if advisors' duty of care or liability to compensate their client for a breach of that duty have been taken away as part of the underlying contract to provide advice, then you can't sue. So this is what might render them inaccessible in many cases. And in the trust industry that I know, such exemption clauses and duty waivers are very common. It may be that in other parts of the professional world, they are less so, but I'm not sure about that. Okay.
Any last questions? Hearing none, let's give another round of applause to Adam for an excellent talk.